Thank you, Mr. Chairman. I am Joshua Houston. I'm the Advocacy Director at Texas Impact, and we're here opposed to House Bill 6. Texas Impact is the membership organization for mainline Protestant, Jewish, and Muslim denominations in the state. The poll watcher provisions and the vote harvesting services definition would adversely affect our membership. We actively encourage and recruit our membership to be election judges for their counties. Our membership is 50% Democrat, 42% Republican, and 8% mixed in their primary voting histories. Excuse me, I ran over here and I'm short of breath. Their diversity helps counties find alternate judges of the opposite party from the primary judge, especially in more politically homogenous counties like, say, in Travis County or Nacogdoches County, just to throw a couple of contradictory, opposite examples, I should say. So should the poll watcher provisions in this bill become law, we would have qualms before encouraging our membership to be election judges again. We have witnessed behavior by poll watchers that is more adversarial than observing. HB 6 disempowers those election judges from both parties from maintaining efficiency and order. We appreciate the removal of the criminal penalties for removing a poll watcher. That reduces our qualms. But we agree with what others have testified and asked questions about, that the language of 3.01 and 3.06 are contradictory and confusing, especially for those little old church ladies that make democracy work. Additionally, something does not need to arise to a fistfight in order to be considered as a disruption. If a judge is sidelined having a 15-minute argument, then that line is going to back up as that judge is taken out of processing voters, and long lines disenfranchise. Additionally, active conflict at a polling location, or really anywhere else for that matter, can be intimidating to some people, some voters. On the vote harvesting provisions, the criminal penalties relating to vote harvesting and the distribution of applications for ballot by mail are vague at best and overbroad as applied. During the July primary, several of our churches undertook campaigns to get their members who were 65 and older to vote by mail, which included mailing and hand-delivering applications for ballots by mail to parishioners. Now, neither Texas Impact or our congregations ever endorse candidates, but 501c3s can and often do endorse on ballot measures, and it says measures in the text. Now, with respect to the Attorney General's office, we agree with what the NAACP testified to about the language of this new committee substitute. We read it to be that we would be felons if we, A, distributed those applications for ballots by mail, 2, during a local or constitutional amendment election, and if we have taken a position on one of those measures on the ballot. Now, we've read the does not apply section on page 16. It is unclear to us what constitutes, quote, direct interaction with an application in the presence of a voter. So, for instance, the University Presbyterian Church of Austin called its members, so that's interaction, and even hand-delivered applications, so that'd be in the presence of the voter, just to make sure that they received an application. Now, we can't tell what specific activities would arise to a felonious level.
Thank you, Mr. Houston. I'll let you go a little over, but I will say there are 143 remaining witnesses. So this time, I have to pause you, but maybe someone could ask you a question, if that's okay. Members, do you have any questions for this witness? Okay. So, my apologies, Mr. Houston.
Thank you for your time.
No, thank you, sir.